So another important aspects relating to Union judiciary of the Constitution of India that we found under Article 141 of the Constitution, which expressly provides that law declared by Supreme Court to be binding on all courts within the territory of India, which we named as judicial discipline, and it is otherwise called the binding jurisdiction of the Supreme Court. So the law declared by Supreme Court would be binding over all courts within the territory of India. So in that case, we will discuss certain important leading case to clarify exactly how far the jurisdiction of the Supreme Court is binding over all courts within the territory of India. And first important leading case that we would like to discuss is state of Himachal Pradesh versus Parasram. In 2008, Supreme Court expressed that the judicial discipline to abide by Supreme Court decision cannot be forsaken under any pretext by any authority or court, be it even high court of any state. And now we'll go to another important leading case, Special Deputy Collector versus Basudev Rao in 2008, where it was pronounced that High Court distinguishing the judgment of Apex Court on ground that there was no elaborate discussion and therefore no reason is discriminable, is clearly violative of judicial discipline as it was pronounced by the Apex Court. So also we'll discuss another important leading case, that is Mariko Tado versus Takam Surang in 2013, where the Supreme Court pronounced that if a single judge of the High Court clearly ignored the binding decision of Supreme Court, the same would amount to judicial impropriety and indiscipline. And now we'll discuss another important leading case, BSG SST versus VR Education Service Association, and it was a case of 2013 where Supreme Court expressed that the judicial discipline requires the court to accept the judgment confirmed by the higher court, and it should not in collateral proceedings write a judgment contrary to the confirmed judgment as it was pronounced by the Apex Court in this important leading case. And now we'll discuss another important leading case, Commissioner of Income Tax versus Son Engineering Works Private Limited in 1993. Supreme Court expressed that what is binding is the ratio of the decision and not any findings or facts or the opinion of the court on any question which was not required to be decided in a particular case. It is the principle found out upon a reading of the judgment as a whole in the light of the questions before the court and not particular words or sentence as it was pronounced by the Supreme Court. And now we'll discuss the rulings in the leading case, State of Uttar Pradesh versus Synthetics and Chemicals Limited in 1991, where Supreme Court expressed that it has led the principles and has laid down that the following categories of decisions of the Supreme Court have no binding force and such as obiter dicta, statements which are not part of the ratio decidendi, and secondly, a decision for in carium, a decision given in ignorance of the terms of a statute or rule having the force of a statute. So also a decision passed sub silencio without any argument or debate on the relevant question, and so also an order met with the consent of the parties and with the reservation that it should not be treated as a precedent. So, the following categories of decisions as laid down by the Supreme Court have no binding force as it was pronounced by the apex court. And now we'll go to another important leading case relating to the binding jurisdiction of the Supreme Court is Vishal Kalsaria versus Bank of India in 2016, and where it was expressed that the binding jurisdiction of the Supreme Court in this important leading case, that is Vishal Kalsaria versus Bank of India, where it was expressed that a word or sentence cannot be picked up from a judgment to construct that it is the ratio decidendi on the relevant aspect of the case. The judgment cannot be read as a statute and interpreted and applied to the facts and situation of every case. And now we'll go to the next important leading case relating to binding jurisdiction under Article 141 of the Constitution is Nirmal Kumar Bhatwayal versus State of West Bengal. In 2016, the Calcutta High Court expressed that a judgment is an authority for the preposition which actually decides and not what logically follows therefrom. And now we'll discuss another important leading case, that is FCJ. FCJ versus Narendra in 1993 Supreme Court expressed its view on retrospective operation, where the Supreme Court has expressly made its ratio prospective. The High Court cannot give it retrospective operation. And now we'll go to another important leading case, and that is Subraya MN versus Vital MN in 1990. Supreme Court expressed that In particular, relating to this important leading case, that this Article 141 recognizes the role of Supreme Court to alter the law in course of its function to interpret legislation in order to bring the law in harmony with social changes. When there is gross error, the Supreme Court can consider whether the finding is wholly inconsistent with the material or record, or lower court has dealt with the evidence in perfunctory manner as it was pronounced by the apex court in this important leading case. And now we'll go to another most important leading case, and that is Supreme Court Advocates on Records Association versus Union of India, and which was decided in 1994, where it was pronounced that stare decisis is not inflexible rule. It has less relevance in constitutional cases. So now we go to another important leading case relating to stare decisis, and that is state of Himachal Pradesh versus Ashwini Kumar in 2015. Supreme Court pronounced that the principle of stare decisis is not applicable if the provisions of the statutes are very clear. Otherwise, even though it has stood for long period, can be interfered with, as it was pronounced by the apex court. And now we'll discuss another important leading case, and that is relating to New India Assurance Company Limited versus Hills Multipurpose Gold Storage Private Limited, which was decided in 2016 by the apex court, and where it was pronounced that the law laid down by the Supreme Court in a larger bench is binding on any subsequent bench of lesser or co-equal strength. And now we'll go to another important ruling, and that is relating to state of Gujarat versus retired Justice R.A. Mehta in 2013, where the Supreme Court pronounced that where a decision was badly argued, inadequately considered, or fallaciously reasoned, it would not lose its authority. And now we'll go to another important leading case, that is P. Unikrishnan versus B.K. Mahanudevan in 2014, where Supreme Court expressed that the binding characters of judgments pronounced by the courts of competent jurisdiction is an essential part of the rule of law. And now we'll discuss another important leading case relating to binding jurisdiction is Chlorocontrols India Private Limited versus 710 Water Purification Inc. in 2013, where Supreme Court expressed that the observation made by the court have to be considered and read to support the ratio decidendi of the judgment. Observation in a judgment which are stared upon by the judgment of a larger bench should not constitute valid precedent, as it will be hit by the doctrine of stare decisis, as it was pronounced by the Supreme Court in this important leading case. And now we'll discuss another important leading case, that is Roger Sashuna versus Mukesh Sharma in 2017, where Supreme Court expressed that about the precedents as relating to this important leading case. It was pronounced by the apex court is that it is a judicial decision containing a principle forming authoritative element termed as ratio decidendi, as it was declared by the Supreme Court in this important leading case, Roger Sashuna versus Mukesh Sharma in 2017. And now we'll discuss another important leading case, and that is relating to binding jurisdiction. And the important leading case is Messrs. Bhagavati Coke Industries Private Limited versus Central Coalfields Limited in 2017. The Patna High Court pronounced that regarding binding force, the view taken by the division bench has to be followed by single bench in case it suffers from glaring error. Matter is to be referred to a larger bench, as it was pronounced by the Patna High Court in this important leading case, Messrs. Bhagavati Coke Industries Private Limited versus Central Coalfields Limited in 2017. So, this is all about judicial discipline and binding jurisdiction, as we found under Article 141 of the Constitution of India, which completely relates to the Union judiciary. So, in our next upcoming video, we would like to discuss another important aspects of the Constitution of India, and that is relating to the governor of a state. And that we would like to discuss in our upcoming